Welcome. Good afternoon. I'm Joe Dumit. I'm a professor of anthropology and science and technology studies and the director of the Institute for Social Sciences. It's my pleasure to introduce you today to our latest installment of the ISS Noon Lecture Series. This represents a continuation of a program launched many years ago by the Institute for Governmental Affairs, a series that has hosted distinguished speakers from UC Davis and beyond, addressing pressing issues of politics and society. So the ISS is pleased to continue this tradition. The Noon Lectures are one of many events hosted or supported by ISS. To stay up to date on these and other events, please check out our website, subscribe to our newsletter. We have lots of opportunities for funding and other forms of support. And we're also on Facebook and Twitter. Before I introduce our speaker today, I'd like to draw attention to our next Noon Lecture, which will take place here in the Andrews Room on Tuesday, May 9th. Associate Professor of Sociology, Drew Halfman, will give a talk entitled Reproductive Rights Under the Trump Administration. I hope you'll join us for that. This afternoon, our speaker is Gerardo Can-Diaz, who joined UC Davis in September 2016 as an Assistant Professor of Science and Technology Studies. Dr. Diaz is a historian of technology and business with a special interest in American law. To talk or work with him is to understand just how wonderful archives can be. He loves combing papers to piece together how worlds and words are made and remade. He's also already an amazing mentor, assisting graduate students finding their own way through dissertations. And he's currently writing a history of software patenting in the United States to be published by Yale University Press. And just this month, he was awarded the Business History Conference's Herman E. Cross Prize for Best Dissertation in Business History. In addition to a BA from Harvard and an MPhil from the University of Cambridge, Can-Diaz holds a doctorate in the history of science and medicine from Yale University. His work has been funded by fellowships from the Charles Babbage Institute, the Institute of Electrical and Electronics Engineers, and the Lemelson Center for the Study of Invention and Innovation. As he presents a lecture entitled What is Software, please join me in welcoming Can-Diaz.
Thank you, Joe, and thank you everyone for coming. So you may have seen this image. If this works, there we go. This image in the poster for today's event. It's a cartoon published in 1963 that makes fun of flowcharts, the schematic representations of the logical structure of computer programs. Flowcharts are the most iconic ways of representing not just computer programs, but also any tasks for which there can be an algorithmic solution. That is, a structured set of unambiguous rules that determine an outcome or accomplish a task. So I want to give you an example. Here's a flowchart for a very simple program. It computes what's called a factorial. That's just a technical name for the product of positive whole numbers up to a given 1. So if you input a 3 into the program, then the computer will output the result of multiplying 1 times 2 times 3, and that's 6. The multiplication happens in this little loop that I just highlighted in what's supposed to be yellow. But here is another way of presenting a program that computes factorials. It's the source code, the human written text of a program written in a language called C. The multiplication in this one appears once again in that yellowish box in the middle. So let's look at these two programs side by side. Both of them spit out the factorial of whichever number you input, and they both have their own loops. But I'm showing you two very different objects. The one on the right includes pictures, rectangles, diamonds, arrows, and shadowing. And the one on the left is mostly colorful text that a properly trained person can read very easily. So when we talk about computer programs, what are we actually talking about? Are we talking about text, about algorithms, or about some other electromechanical processes that neither one of these objects can actually convey in full? So a few years ago, the fact that objects such as these ones include text and images inspired me to look at the history of copyright law in search for answers to those questions. Copyright is the standard form of protection used for creative works such as books, photographs, musical recordings, and television programs. It's a form of intellectual property law, or IP, which also includes stuff like patents and trademarks. Today I'm going to examine the history of copyright law since the 1960s in order to reflect on the deceptively simple-sounding question that brought us here today. What is software? I'm going to focus on the work of a group called the National Commission on New Technological Uses of Copyrighted Works. CONTU, as this group was known, was a commission created by Congress in 1974. Lawmakers made it in the hopes that the group would enable them to set aside discussion on technological matters in order to pass what would become the Copyright Act of 1976. That's the act that continues to govern copyright in the United States today. Now, the commissioner's work on software copyright sparked a very curious process in the history of digital technologies, as some of the most prominent actors in the computing industry appeared before CONTU one by one to answer our key question for the day. Their answers fell into three categories. First, spokespeople for hardware manufacturers and software firms argued that software is a text just like any literary work. And second, prominent academic programmers argued that software is instead a machine and that it is therefore best suited for patents and not copyrights. And third, spokespeople for industrial research laboratories argued that software has a dual nature, that it can be at once a text and a machine, depending actually on when you look at it. So in short, three coexisting conceptions of the nature of software as an invention came into conflict with one another. These conceptions were not inconsequential sparks of rhetorical and legal flair. On the contrary, they were designed to advance long-term business strategies and research agendas. They were representative of different cultures of software making, and they actually continue to shape the ownership of software today. For these reasons, my goal is not to choose any of these conceptions as the preferred one. Instead, this talk is about why and how this question matters, and it addresses answers to the questions itself as much as it does the entanglements of business and law that have made them important. I will open with a brief introduction to the joint histories of intellectual property and information technologies aimed at sketching the commercial significance of software copyright and setting the stage for the work that CONTU did. I will also analyze the origins and details of the conceptions of the nature of software that CONTU consider, and then, after accounting for the views that the commissioners expressed themselves, I'm going to end by addressing the impact that CONTU's preferred answer to this question continues to have on software law today. All right, so let's get started. In the mid-1960s, firms of all sizes started to wonder if they could start selling their computer programs. Until then, programs were something that people could obtain for free, they could lease them, or perhaps they could have them developed especially, but they couldn't buy it. There was no such thing as an off-the-shelf software product as we know them today. Managers at many firms were tempted to start selling, but they feared that doing so would leave them vulnerable to piracy, because it would require them to abandon the anti-piracy provisions that they normally included in their leasing or custom development contracts. For this reason, as managers started to gravitate towards the idea of selling programs, many lawyers and legally inclined engineers started to inquire into the legal protections that would enable them to do so. Among the latter was John Banzhaf, a second-year law student at Columbia University who held an undergraduate degree in electrical engineering from MIT. In 1964, Banzhaf contacted the Copyright Office to register 2 of the programs that he has written. Now, registration is just a legal formality. It establishes a public record for a copyright claim, and it's required before any infringement suits or damages can come to a conclusion. It serves as incontestable proof of the validity of a copyright. But what's more important for our purposes is that the act of applying for a registration requires the Copyright Office to categorize the work about to be registered. And the common categories at the time included books, sound recordings, pamphlets, photographs, but there was no such thing as a software category. Less than a month after Banzhaf's submission, the Copyright Office accepted his registrations, but not on the grounds that software itself could receive a copyright. Instead, the registrations had been the result of the office's rule of doubt policy, which said that any difficult cases would be resolved in the applicant's favor. Starting with Banzhaf's programs, the Copyright Office decided all software would be classified as books or pamphlets, and not as a new category of copyright-eligible work. Now, the resulting protection from this decision was very weak. It basically meant that a programmer could copyright the text that she had written in a programming language, but then any other programmer could write the same program in a different language and end up with software that did the exact same thing without committing infringement. So for this reason, some of the more experienced lawyers interested in selling and protecting software turned away from copyright and towards patents. Many of them had seen hardware firms and industrial research laboratories, such as these ones, secure patent protection for their computer programs since the early 1960s, and they were now encouraging software firms to do the same. But the stakes of securing these patents became especially high in 1969. That's when IBM announced its so-called unbundling announcement. That was the announcement that the firm would start selling its programs instead of distributing them for free. IBM never officially explained why they did this, but the most likely reason was that the Department of Justice was inquiring into whether or not it was legal to continue distributing the programs for free. Now, IBM's unbundling was a very important turning point in the software industry's history. Prior to it, the industry was generating between $20 and $50 million in revenues every year, and soon after unbundling, revenues shot up to surpass $300 million every year. Established computing firms started to sell their programs, all eager to compete with IBM, and they were hopeful that perhaps these patents that they were trying to secure would be sufficient protection against piracy. But they soon ran into a very big problem. In 1972, the Supreme Court handed down what would become one of the most prominent decisions in the history of American patent law. It's called Gottschalk v. Benson. Benson, as this decision is known, concerned a computer program created by two employees at Bell Telephone Laboratories who had devised a way of using a computer to translate numbers from one system to the next. Their application was held up in the Patent Office for 9 years until the Supreme Court ruled that the invention amounts to a series of mathematical algorithms and that it is therefore ineligible for patent protection. The Patent Office interpreted Benson as a nearly absolute ban on any kind of software patenting. This motivated lawyers at firms and industrial research laboratories to turn their attention back to software copyright in hopes that it wouldn't be as worthless as they thought. After all, some copyright protection was much better than no protection at all. But the 1970s had brought with them not just an all-time low for software patenting, but also one of the most turbulent periods in the history of American copyright reform. Lawmakers at Congress had been attempting to overhaul the nation's copyright system for nearly 2 decades, but bureaucratic and political disagreements had repeatedly brought them to a halt. In the early 1970s, they were finally approaching the passage of a new Copyright Act, but one more hurdle stood in their way: the fear that computers could soon enable users to unleash a wave of paperless copyright infringement. This fear was grounded on two developments. On the one hand, the spread of networking had demonstrated that information can travel across vast landscapes from one computer to the next. This was especially visible in Minnesota, where a state-sponsored project was enabling this kind of communication. And the second development was the spread of photocopying. In the 1960s, the use of photocopiers had wreaked havoc on the publishing industry. Journals were closing, people were canceling their subscriptions instead of purchasing the issues themselves, and the publishing companies were becoming extremely litigious. And it was in response to all these developments that Congress created CONTU in 1974. Lawmakers agreed that the spread of computers and photocopiers created important problems, but they didn't want to delay their efforts to pass a Copyright Reform Act any further. President Gerald Ford agreed, and in 1974, he appointed 12 commissioners to CONTU. These commissioners, here you see them posing with some assistants. They represented the interests of copyright owners, users, and the general public. They included the Pulitzer Prize-winning author John Hersey, the Harvard law professor Arthur Miller, the head of the University of Minnesota's library Alice Wilcox, a prominent copyright scholar called George Nimmer, Melville Nimmer, a former register of copyright called George Carey, and then at the end, Rhoda Karpatkin, who was the executive director of the Consumers Union. The commissioners carried out the most extensive federally sponsored review of the computing and publishing industries that had ever occurred. They address several problems, from the lack of copyright infringement notices in copyright centers and the copyright protection of databases to the copyright eligibility of software. And that's what interests us. One note on the language before we move on is that these people use the terms software and computer programs interchangeably, although they sometimes use the word software as a plural for program. They did not conceive of any technical or discursive distinctions between the two terms, and in fact, throughout their meetings, they often changed their terms in order to match whatever usage they found in the documents and testimony they were studying. With all of this in mind, let's move on to the conceptions of the nature of software that they considered. Here's the first one, that software is a text. Cantu's work on software copyright began at IBM in December 1975, when one of the firm's lawyers, Joseph Taphorn, took them on a tour of the company's facilities in White Plains, New York. Taphorn took the commissioners from room to room, showing them a collection of devices that were probably unfamiliar to most of them. Printers, card readers, and even full mainframe computers that were the size of this room. Towards the end of their tour, the commissioners met Ralph Gomory, IBM's vice president and director of research. Surrounded by IBM's hardware, Gomory casually outlined his vision for what the future of the computing industry would bring. He explained that as computer networks became wider and denser, and machines became more widely available, transmitting any work from one computer to another would become a pedestrian task regardless of its copyright status. Taphorn and Gomory presented the commissioners with a view of the future in which poems, books, and maybe even images and computer programs could be transmitted from one machine to another as easily as television sets received their signals through broadcasting or cable. They were completely right. To reproduce these materials, users would just need to press a button. But unlike the copier buttons, those on a computer did not create any printout. A computer-assisted reproduction and transmission could be nearly untraceable. Gomory and Taphorn also gave the commissioners a copy of IBM's decade-old pamphlet, Programming, Words That Move Machines. The pamphlet explained that just as a writer can use the letters of the alphabet to produce all the words he or she needs, a programmer can combine basic computer operations into a limitless number of programs. Indeed, it said, the essence of programming is translating concepts and commands into languages that machines can read. The pamphlet also predicted that programming would always be a hybrid between a science and an art. On the one hand, the science would require programmers to analyze problems and reduce them to sequences of small steps that a computer can follow. And on the other hand, the art would require them to select, connect, and use these steps using words. Now, this pamphlet was above all an ad. It emphasized how IBM's engineers had become so good at using words to move machines that the firm's computers could meet a wide variety of needs, from the mundane performance of arithmetic operations to the most complex computational problems in engineering and finance. But at the same time, this pamphlet had become one of the most important documents in IBM's engagement with IP. From the mid-1960s to the 1980s, the firm's lawyers cited it when they filed briefs on software patenting or delivered written testimony at courts or Congress. They even sometimes included the whole pamphlet itself as part of its own legal briefs. But back at Cantu, Taphorn and Gomory's explanations and their pamphlet encouraged the commissioners to embrace the textual nature of software. Following IBM's lead, they agreed to define a computer program provisionally as, quote, a fixation of a series of statements or instructions to be used in conjunction with a computer in order to bring about a certain result, unquote. They also considered recommending to Congress that the Copyright Act should be amended to make computer programs copyright-eligible texts in their own right, and not as books or pamphlets. I should note here, by the way, that the word fixation is a standard term in copyright law. It refers to the inscription of a work in a tangible medium like paper, film, and so on. So this definition is general enough to allow for the submission of programs inscribed in stuff ranging from newspapers to magnetic tape. Now, in order to assess the viability of this definition, the commissioner decided to hear testimony from whatever parties were interested. And at this point, they encountered a second conception. Number two is, software is a machine. The commissioners invited Joseph C. Licklider, the internet pioneer, to speak in representation of programmers at universities and the federal government. Licklider is one of the most prominent figures in the history of computing. In the 1960s, he had served as the director of ARPA, that's the organization that would later become DARPA, the Department of Defense Advanced Research Projects Agency. Through this group, he has selected, funded, and directed research groups on networking, interactive computing, and all sorts of other interface problems at universities across the country. In the 1970s, Licklider was still striving to create what he called computer utilities. Those were service bureaus that sold network computer processing time to small users who could not afford to buy machines of their own. He was now a professor at MIT, and he remained very prominent and very interested in the legal implications of networking. At Cantu, he delivered the kind of argument that industrial research laboratories had made repeatedly at courts in the patent office, that software is a machine best suited for patents. Licklider told the commissioners that their textual understanding of software bothered and distressed him, and he fell short of telling them that they were entirely wrong. Certainly, he said, text in a programming language can be transmitted from one computer in a network to the next, but Licklider argued that programs should not be reduced to the texts that programmers use to construct them. To him, a program was ultimately, quote, something that gets slipped into a computer, unquote. It may include textual instructions, but for these instructions to become useful, they require a computer. Unlike a poem or a novel, a program is worthless without this connection to a device. For this reason, Licklider believed that it was a mistake to think about a computer program as a description of a process or as a set of instructions, regardless of the medium in which they were fixed. He explained that whether a program is more like ink on paper or holes in a punch card is irrelevant. Instead, it was enough to realize, quote, that software is a machine, that is, something which, when activated, when energized, behaves and produces process, unquote. This meant that the problem of securing intellectual property protection for software amounted to recognizing that protecting the code that a programmer wrote did nothing to protect the program itself. All people want is the effect of the action of the program, he explained to the commissioners. They don't care a thing for the particulars of the expression. Now, to the commissioners, Licklider's testimony, together with IBM's teaching, suggested that software was either a text or a machine. It wasn't such a novel object that it couldn't fit into one of those categories, so all they had to do was to decide which one of those it was. Hoping to gain some additional insight, they invited spokespeople from industrial research laboratories to testify, and boy did they regret it. This brings us to the third conception of the day, that software has a dual nature. Now, Robert O. Nimtz, there are no pictures of him anywhere, so here's Bell's logo, was a staff lawyer at Bell Telephone Laboratories' IP division. Bell was not a software firm, but its internally developed programs controlled some of AT&T's proprietary telephone switching mechanisms, computers, and scientific equipment. For this reason, lawyers such as Nimtz had developed a very keen interest in the IP protection of computer programs as early as the late 1940s. But more recently, Nimtz had served as one of Bell's key legal counsels for the conflicts that had culminated with the Benson case, and his work on the patent eligibility of software had risen to national prominence. At the same time, like many other IP lawyers interested in software, he had developed a very keen interest in copyrights after Bell's resounding defeat in the Supreme Court. At Cantu, Nimtz warned that Congress and the Commission had failed to realize that software is, quote, radically different from any other subject matter ever to fall under the purview of copyright, unquote. Like Licklider, Nimtz believed that regardless of how firmly copyright law could restrict the use, reproduction, and distribution of the text of a computer program, it would fail to protect what was actually the program's valuable subject matter, its uses. Nimtz's views were grounded on the idea that the nature of software was a function of the relationship between its history and its medium. He explained that software could be found in two mutually complementary and coexisting forms. When a program is born, it is a text. flowcharts, source code, and verbal descriptions of algorithms. In this form, software is a writing akin to books and poems, and so it is eligible for copyrights. But NIMS added that the journey of a computer program from the programmer's mind to the work of an actual computer involved more than just the making of text. At some point, the program would need to be fixed in a machine-readable medium such as magnetic tape, or else no computer would ever be able to run it. Once this fixation occurred, quote, not for the purpose of recording or storing the information in the writings, but for the sole purpose of controlling a machine, the program entered maturity, unquote. At this point, it ceased to be just a text, and it became what he called a machine element, thus making patents the legal protection most appropriate for them. So NIMS was in fact arguing that Licklider and IBM could both be right at the same time, depending basically on when you looked. And this was a big problem. Many of the commissioners had hoped that NIMS could serve as a kind of tiebreaker, and perhaps, given Bell's struggles, they even hoped that he would side with Licklider. But the real tiebreaker turned out to be not any sophisticated conception, but partial industry consensus. And this came in 1977 as the commission started to draft its final report. Virtually every computing firm that submitted testimony on software copyright welcomed Cantu's take on IBM's conception of software as text. Their collective brief suggests that as far as the industry was concerned, Cantu had gotten the gist of software just right. Here's one of the most illustrative examples of this widespread approval. This is the prominent programmer and manager Marty Goetz from Applied Data Research, or ADR. Over the past decade, Goetz had gained notoriety in the software industry for his involvement with IP, and especially for his strong support of software patenting. He had even obtained in 1968 the first software patent ever obtained by a software firm, that's a sorting system. Since then, ADR had secured copyright protection for all its major products, and its bestsellers were protected by patents and copyrights at the same time. And along the way, Goetz had become a key member of the IP task force at ADAPSO. That's the main trade association for software firms. At Cantu, Goetz told the commissioners that copyrights would give his company the additional protections that it needed in order to remain competitive. And he insisted that programs are essentially texts that could be translated from a programming language into machine language. Now that the Benson decision had made the future of software patenting appear uncertain, software copyright was the last line of defense that would enable firms such as ADR to sell software without the fear of piracy. Arguments such as this one suggested to the commissioners that the intellectual property protection of software, which could be partially achieved through copyright, hinged on affirming in public that software is a text. If computing firms and industrial research laboratories were willing to accept at least partially a textual nature of software, then it didn't matter to them that academics such as Licklider didn't. In 1978, Cantu released its final report. This document advanced the textual conception of software that the commissioners had embraced after their visit to IBM, and it proposed that copyright law should indeed be amended to declare that computer programs constitute a new category of copyrightable text. The one commissioner who disagreed was John Hersey. Now, the involvement of a Pulitzer Prize-winning novelist in determining what software is rather unexpected, so I'd like to tell you a little bit about Hersey and the views that he expressed. Before joining Cantu, Hersey had become a central creative and political figure in American fiction, nonfiction, and journalism. And his first novel, A Bell for Adano, had won the Pulitzer Prize in 1945. President Ford had appointed Hersey to Cantu in the author's capacity as the president of the Authors League of America, and he was there in order to ensure that the interests of novelists and nonfiction writers would be represented in the discussions. But what interested Hersey most about software were not the technical details of computer programming, but the fact that programs include words. Software seemed to him a blend between a traditional text and a machine, a hybrid object that replaced human creativity with the potential for mechanical and electronic efficiency. As a result, he had gravitated towards Licklider's mechanical conception, and he had found himself agreeing a little bit with some of NIMS's duality. Cantu's ultimate decision to side with computing firms by choosing a textual conception of software struck Hersey as an affront to human culture. In his view, copyright protection was intended for categories of media made by and for humans, including, quote, written words by the human hand, music by the ear, and paintings by the eye, unquote. He complained that the commissioners were polluting both human creativity and the notion of a writing, and that thinking of software as a text is, quote, a dangerous blurring and merging of human and mechanical communication, unquote. Hersey told the commissioners that their blurring of the qualities that separated human beings from machines equated the work of a computer with literary expressions of human emotion. The great danger in doing so was that a culture that accepts the equivalence of people and machines would eventually become unable to experience, bring to life, or even communicate what he called the bundles of qualities that comprise humanity, by which he meant emotions such as courage, fear, desire, and hope. But the rest of the commission disagreed. In the final report, they explained that Hersey's efforts would yield a proposal to legislate in a way that would give the federal government the right to assess the merits of a work and choose only those works which, in its view, are good enough for copyright. This would create an unfair distinction between works of great and small aesthetic value meant to determine copyright eligibility. So they believed that extending protection to computer programs was essential to ensuring that copyright law applied to all forms of expression. In fact, they explained that rejecting Hersey's views was the only way to ensure that the United States would have a copyright law broad enough, quote, to shelter the works of Nobel laureates and computer programmers without causing any confusion about which is which, unquote. Now, I would like to end by outlining the long-lasting impact of Cantu's work. The Commissioner's recommendations on software copyright did not face any opposition in Congress at all. In 1980, lawmakers passed the Computer Software Copyright Act, an amendment to the Copyright Act of 1976 designed almost exclusively to incorporate Cantu's recommendations into copyright law. The Act defined computer programs as software firms and hardware manufacturers understood them, namely as, quote, a set of statements or instructions to be used directly or indirectly in a computer in order to bring about a certain result, unquote. The only difference here, by the way, is the absence of the word fixation that I highlighted earlier, and the addition of the phrase directly or indirectly, which would continue to allow the submission of programs in a wide range of media. In fact, people started submitting whole bundles for copyright registration, including source code, flowcharts, verbal and graphic descriptions of the program, and supporting documents. And by the mid-'80s, they were submitting even pictures of graphic user interfaces, computer-generated sounds, and even video game character designs. This flexibility triggered a very sharp rise in copyright registrations. By 1985, the Copyright Office was accepting over 5,000 yearly registrations for computer programs, at least 1,000 more than the total registrations accepted from 1964 to 1980. Because of the classification problems that I told you about, whether they're books or pamphlets or actual software, we don't have year-to-year data, so all we have so far is cumulative data. Nowadays, the Copyright Office is registering several thousand computer programs per year, although there is a bit of a decline right now. And Cantu's definition has become axiomatic to American copyright law. For example, here is the latest version of Circular 61, the document that outlines the Copyright Office's standards and procedures for software copyright. Right under the title, you can see Cantu's definition of computer programs as passed in the Computer Software Copyright Act. But at the same time, this embrace of IBM's textual conception of the nature of software continues to generate one of the problems that John Hersey had worried about the most. Since the 1980s, judges across the country have struggled to identify which parts of a program constitute its copyright-eligible expressive creative elements, and which ones are merely technical elements required to enable the program to work in a particular machine. Indeed, Cantu's recommendation in the 1980 Act left to the courts a difficult puzzle that has not yet been resolved, crafting standards to distill creativity from utility in a computer program. The The spread of software for PCs in the 80s, home internet in the 90s, and app programming today has made this far more difficult than ever before. But the significance of Cantu's story transcends the legal contexts in which it unfolded. For contemporary scholars with an interest in digital technologies, this carries with it a very important warning. The act of choosing a conception of the nature of software as an invention can inadvertently infuse our analysis with legal, political, and commercial biases that we may or may not want. As emerging fields such as software studies continue to gain momentum, we would do well to keep in mind how what we think that software is can be shaped not by the technical specifications of our programs, but instead by the political economies of the industries that produce them. And that's it. Thank you.
Want to field questions?
Sure. Jim.
So if I write a program in a piece of DNA and put it in a cell, I'm struggling to figure out what the difference is between an expressive and a technical element is. And since an artificially produced piece of DNA is patentable, does that further complicate the picture that emerged for the dual nature here, or is it just an instance of
It does, but indirectly. So, if you write a program in a piece of DNA, you will be inscribing it, you will be fixating it, but not in a human-readable medium, which is going to be one of the requirements that the Copyright Office would look for. So, in terms of copyright law, you will probably not be looking for the software copyright itself, but the fact that you can write down the program in something that is patentable does indeed complicate that relationship between what's expressive and what's useful. And in fact, that's the great tension of a lot of the firms that had simultaneous copyrights and patent protections for their programs they faced. It was that on the one hand, they had to go to the patent office and the courts and argued that they had a new and useful machine or process. But on the other hand, they had to go to the Copyright Office and argue that they had a creative expression. So it was basically, for many of these firms, especially the most recognized lawyers, it was just a juggling act of conceptions of the nature of software, depending on the case at hand. And that happened, in fact, to Getz. Getz had become very popular by the 70s for arguing that software was a machine that required patents. But then, after Benson, that he had no faith left on the patent system, sort of switched the game and went with the textual conception.
Just quick follow-up. So microfiche is human readable if you put it in a machine that makes it big enough you can see. But a piece of DNA is readable if you put it in a sequencing machine that displays what the nucleotide.
But the microfiche is a reproduction of a thing that has already been copyrighted, right? So you have the page that becomes archived in microfiche, and the copyright will fall on the page, not on the microfiche. The microfiche itself, you would probably not get a copyright for that because the argument would likely be that there's no creative work involved in transforming the copyrighted page into the microfiche kind of thing.
So these days, software engineers have intentionally abstracted away from the machine-dependent nature of code. So for example, like Java code is made to run on the Java virtual machine, which could sit on your Android phone, your Mac computer, your PC. Python code is made to be interpreted on all sorts of machines. Do you think that this intentional design by software engineers in order to make machine-independent code has shifted the debate into thinking of code more as text than in the past, where more infrastructure and other things were required before the widespread use of personal computing?
I think it had definitely shifted the perception of code as programs as more than text, but and the courts, the notion of software as a machine, or at least as a component of a tangible mechanical process, has not disappeared. basically because, and it's not going to disappear anytime soon, I think, but basically because one of the common ways of securing patent protections for programs has been to argue, even at the height of the software as a text sort of frenzy in the 70s, has been to argue that the program itself is a controlling mechanism for some other process that causes the tangible transformation of an object. So that tangibility has not been lost in terms of how they describe software in legal contexts, but certainly the perception of software as text has been fueled by that.
But the tangibility is abstracted from the machine, and that like a tangible result of code might be a function that turns some text into some other text, regardless of the machine, like floating in some cloud or on your laptop.
So that is as old as software itself.
Right.
So text transforming into text, that's just sort of one step away from electricity turning into electricity in terms of the legal metaphors that are used to describe software. But what I think that what's more important is not which of these conceptions rises or falls, but instead the fact that there's nothing about the programs themselves that determine what software is. That what software is the subject of negotiation of qualitative matters and not an examination of technical considerations. There's as many technical considerations as you want, and in fact, with the current Oracle and Google debates, there's a lot of discussion going on about whether copyright should still continue to apply to this or that. But what matters here is not whether or not the textual nature is the ruling one, but the fact that that is the result itself of a negotiation independent of what software has been. Let's go like this.
Thank you. One word that kept coming up that seemed to set the stakes of the question of IP from the beginning is piracy.
Yeah.
But it feels like there's a very different notion of what piracy was then. And I'm curious, was it always the word piracy from the beginning? And so I'm just curious if you can trace a little bit about that word.
So the word pirate, I've seen it starting in the 60s, but not as in the sense of a person at home reproducing. I've seen it in the sense of a thug large corporation trying to drive us out of business by stealing what we have. So the pirate was IBM. I haven't seen it earlier than the 60s in that context, but the meaning itself has changed from a word to describe the large corporation trying to drive the small fledgling firm out of business to, in the 1980s, when people had more access to computers, to the reproduction. And in fact, in the 1980s, that's when I start in the archives, that's when I start seeing actual people, actual pictures and cartoons of people dressed as pirates sitting down in front of like an Apple II. So it's this. So there's like a pirate with a parrot and like a little wooden machine in front of them.
Right.
It's wonderful.
So I guess I'm just curious, and maybe you don't have this yet, but what's the context for which IBM could be the pirates? Like, what's the
the context? It's incredible market dominance. So basically, IBM up until 1969, it distributed all its programs for free, which meant that anybody who actually might want to consider perhaps paying for a program would first have to decide that IBM's free programs were not good enough. So then, as firms started their efforts to sell their programs, they started to wonder, well, first of all, we have to convince the client that paying is better than getting it for free. And second, we have to do something so that IBM can't ruin our business. And that's where IBM became the pirate, because it was, in fact, they did this all the time, that as soon as a small firm released a program, IBM would try to follow suit with a free alternative to drive them out. So that's where that vision of IBM is the thought came from. Yeah.
So I have a specific question and then a question about the methodology as a historian engaging in this. So I didn't know. It's very interesting what you found at the Beinecke library, all the minutes of the meeting. I did not know of the connection between Hersey and NIMS.
Uh-huh.
And I totally buy it, you know, to the point that actually it looks like Hersey used some of the language, like, you know, Hersey refers to the difference between mature programs, which he means when the program runs on the computer, as opposed to the writings that take place as a coder writes the code, right? So the written program is not mature. Mature is when it actually runs on the computer and does its thing. So which is exactly border. So the thing is that I would give Hersey a lot more credit than you did.
Okay.
In the sense that Hersey's point, I don't think it's about the anxiety of you know, the destruction of human culture. His point is actually quite technical. He says, copyright has been so far protecting things that in one way or another are about communicating with humans. This thing does not communicate to humans. So his point is technical. And he makes the intermediate example of the phonorecording, right? Because in copyright law, there is this strange, the copyright says, you know, protects text, images, blah, blah, and phonorecordings. And people say, no, what the hell, why not? Because phonorecordings, you don't see the music, right?
Yeah.
So the phonorecording does not talk to you, but then it does once you put it on a machine. Right? So the phonorecording eventually communicates to humans the music or the text through a machine, and instead the computer does not. The computer, you know, uses it to do other things. So his point is really about communication to humans, which is different to the spin that has been put to that about creativity versus functionality. Because Hersey did not say communicate creative things to humans. He just said this thing does not communicate to humans. This thing is not intelligible to humans. He didn't draw the difference between creativity and functionality. So what I'm saying is that his critique is actually deeper, and it's not reducible to the spin, which is the spin of copyright law, which means that once you accept that these things are copyrightable, then you start talking about them as what is the creative part and what is the functional part. Hersey is saying, no, there are apples and oranges. And Nimmer, who is the god of copyright at the time in the US, writes his opinion in Contu that is a lot sympathetic with Hersey.
Mm-hmm.
And he says that he's not convinced about the fact that the commission wants to say that software is copyrightable. He goes along, but he's not too convinced. And then he says, I think an intermediate test would be this. I think that software should be copyrighted when it produces something that could be copyrighted. So if I have a computer program that generates music, that's copyrightable because it produces something that will be copyrightable, which is pretty cool. Right? Because so in a sense it says that I don't have a problem if a machine produces something creative which can be copyrighted. Right? Instead, if the machine churns things that are not going to be copyrightable, like data, then it shouldn't be copyrightable, which actually is a lot closer to current debates about Alice and so on. So what I'm saying is that I think you are, you know, so and this dovetails with the methodology. I agree 100% with what you're saying, except the ending. There are philosophical questions here that are not reducible to political economy. I think you can't simply say, look, you know, there are different conceptions of software. Depending which one you pick, you buy into certain values, and the ones that survive is the ones that fit the political economy. There are philosophical issues here that are not reducible. I'm not saying that we can get them right, but I'm not saying, so I think you should be a little more the mathematician than the historian. There are issues here that are not reducible to political economy.
Yeah.
There are philosophical issues, and they're going to stay philosophical issues. I know what I'm saying could be read as establishing a hierarchy between disciplines. I'll take the fifth on that.
I actually completely agree with that. So there are a lot of the conceptions that don't survive can't be reduced to political. I think my point in the very, very last sentence was just to highlight, especially for fields such as software studies, that we tend to forget the fact that many of these conceptions are not just that many of these problems are not just philosophical or conceptual, but they're in fact they can be loaded with these issues.
But I would say the opposite, in the sense that otherwise it's always the story. Oh, wait, look, this is a stupid conception, but what the hell, IBM, pushed it through. I mean. I mean, that's a version of history of the victors, right?
Yeah,
I
absolutely.
mean, do we want to keep writing the history of the victors, even while blaming the victors? I don't know.
Can I ask something that probably dovetails on what Mario's...
Before that, we should get to the question.
That's fine.
Okay.
Yeah. Okay, so I was thinking in terms of... So towards the starting, I think it was in one of the cases judgment where you pointed out that one of the problems was that computers could be mathematical, programs could be mathematical algorithms,
Yes.
right? And I'm wondering as to why that never came up again in Conto's meetings. And here what I'm thinking of is that, and it's again largely, as Mario pointed out correctly, I think could be construed as a philosophical question, in that copyrights, if they were for creative expressions, would fall on the somewhat arbitrary scale that I'm picking in my own head between expressive ideas versus patents which were actionable. You could have an idea, but you need to show as to how exactly the mechanics of it would work. And then somewhere out in the domain falls mathematical sort of things, right? Like things that are axiomatic. And it seems like programs themselves would borrow from all of these things. I mean, probably less so from the freewheeling expression that we associate with the arts, but more so from the other two things that I said.
Yeah.
And I wondered why the mathematics part of it was completely lost.
Do I have something for you? Okay, so look at this picture. So, the color scheme, it might be more noticeable, but basically the conceptions of text and machine that I mentioned are at the bottoms of this triangle, and the notion of an algorithm is at the top of the triangle, and it's in the red. So basically, this is my way of representing the different conceptions of the nature of software that were at this interface between IP and IT. So text and machine. This is basically where the Conto debate that I mentioned just unfolded. So
Right.
we have here text, we have the firm, so machine, we have Licklider, in the middle we have the industrial research laboratories. The conception of an algorithm, why it didn't go into the Conto discussions, my first guess is simply that no one brought it up, but that's a bad guess, because the real reason was that the algorithm question was already so unbelievably prominent in patent law. So it didn't come to the copyright distinction, in part because they started to realize that perhaps not all programs were in fact about math. that some of them could be about signal processing that could not be reduced to the numbers. But in the patent context, the algorithm was very, very alive and well. And ironically, if you think about where the algorithm conception and the machine conception are coming from, so in Contour we have machine conception, academic computer programmers, right? Algorithm, we also have academic computer programmers. So we have this entire end of the spectrum of conceptions of the nature of software that the academic computer programmers were sending in. In particular, so one of my favorite moments was in one of the patent cases that I read. A patent examiner was trying to find a way of saying that this patent should not be issued. In fact, it was for Benson. And what he did was that he opened up Donald Knuth's The Art of Computer Programming, the very landmark case, and Donald Knuth at that point said, look, an algorithm requires you this is a manual basically, right, a programming text. Any algorithm will require you to take a pencil and put it to paper. So at some point, some version of that phrase is in there. And then the examiner at the patent office said, look, Knuth says that any algorithm requires paper and pencil. Paper and pencil is a kind of machine. That means that any algorithm requires an implementation. So despite the fact that this patent application is telling me that they have a machine invention or a process invention with a tangible thing, that doesn't count, because that is just a requirement of what an algorithm is. So that sort of blurring, I think, kept the algorithm conception in the patent realm very, very well entrenched.
But today, in the academic CS sphere or almost elsewhere in the industry, where you see the focus being on black boxing the algorithms, do you see that conception changing anything? The fact that, I mean, I don't really know if the industry, apart from the copyright positions, thinks of these things as conventionally speaking texts anymore. I don't know, I feel like the focus is all on algorithms. Does that change anything?
Yeah, so absolutely, and what's happening is that the algorithms are now trade secrets, basically.
Right.
Right. The big elephant in the room that I didn't mention is that underlying this entire current of patents and copyrights, there's a different rise and fall dynamics of trade secrecy, and that's another place where the algorithms were getting tossed into.
Okay.
That's the last question.
So I was fascinated, even though I didn't have the least idea of what you were talking empirically.
Okay.
So that was really one of the first times that happens to me where I don't know anything of what's being the empirical subject matter, and I am completely fascinated by it. And I think that I was fascinated because, not that I think, but I was fascinated because of your analysis. And I think that what to me you were saying is that software was an incredibly complex practice object that was in search of a concept, and this search was itself a conceptual practice. So it is this recursiveness that really produces the inseparation, I don't know how to say it otherwise, the inseparation of practice and concept that attracted me, that pulled me to your analysis. And I there want to connect with Mario's philosophy and political economy, because I think that distinguishes something that I think in your practice is indistinguishable. Because in that negotiation that you're talking, and you separated it at the end, and that there I agree with Mario. Because in your analysis, what you're doing is making this very complicated connection that you have not spoken about, philosophy and political economy coming through all the IBMs and the rest that come into the negotiation that are not without philosophy either. So that the complexity, the connection between concept and practice, and the idea of software not being able to emerge until it becomes a concept, and the emergence of the concept being itself a conceptual practice, is what I I wanted to remark upon what you were saying.
Thank you, Mark. Thank you. And I'll actually take this critique of the separation not being necessarily robust, and I'll work on that. And I'll give you so one place, I didn't mention this here, but one place in which this phenomenon that you highlighted occurred very noticeably is in the transition of software as a service to software as a product. Because right before 1969, the word software included not just the program, but the team of people who would come in and service your computer to install and upgrade it. So this notion of the conceptualization as a practice itself became itself a practice. It became a practice. It was this moment when it got even more blurred, because not only were they seeking a conception of what software is, but they were also at the same time doing software. So it's a very that's actually one of my favorite things when I run into these very messy, blurry things.
Thank you very much. It was a great discussion.